students of the Advanced Private International Law, that I am going to deal today, conflict in the contract under the Private International Law, and here that I share the file, and which is contract. So what is the connecting factor for the contract? Anyone? Now, what is the connecting factor for the contract? I already shared here on the screen. I already shared in the screen, but you are not giving the answer to my question. It is the lex loci contractors. That is the connecting factor. And another factor also, the lex loci actors also there. So general rule, lex loci contractors, the law of the place where the contract is made are entered into the govern with respect to its nature and validity, obligation and interpretations. So where the contract is made are entered into the govern. That is called lex loci contractors. But when you say lex loci actors, where the contract is in action. See, you can make the contract in America, but the action is there in Tanzania, because that will be going to be implemented in Tanzania. So at that instance, we can say the lex loci actors. But the contract where it is made, it is the lex loci contractors. Is it clear? Say yes. Is it clear?
Yes, sir.
Okay, now let us see the exceptions here.
Yes.
Yes, exceptions we will see here. Number one, when parties agreed to the choice of law. See, even you can make a contract in the London, but if you choose the law of India, the Indian law would be applicable in case of the breach. So when parties agree as to the choice of law, and we have seen the case law, Dawson versus Tenesco. What they told, what they made the agreement? If any breach is there, ICC tribunal is having the jurisdiction to entertain it. Are you hearing me? Say yes.
Yes, Prof.
At the time,
Yes.
when they agreed, Tenesco agreed over there and filed a case in the High Court, but High Court denied it because you made that agreement. If any breach is there, that court, that trial court, that is arbitration trial court is having the jurisdiction to entertain such a case, and there is no natural justice is violated, and there is no coercion, there is no any wrong, hence that is the validity is there. And the Court of Appeal also confirmed the validity of the High Court of the Tanzania. We studied there. So number one, that is the point. Number two, lex res site. In case of a contract affecting land or title thereto. If it is land is there, what is the connecting for the land, immobile property? Lex res site, or we can say lex situs. Lex, just we can say lex situs. S-I-T-U-S, enough. So there, the law of the land will be applicable over there. So these are the two exceptions to the contract. Now, lex loci contracts govern only with the respect to the forms, and only the forms it governs, and solemnities of the contract, extrinsically validity, intrinsic validity is generally governed by the national law of the parties. So it is very, very much clear. When you are making the contract in London, London formalities should be followed. What essential of the contract. But when it comes to the matter of the substantial law is concerned, generally the place, the citizens of the country, domestic law would be followed. Either it is a Tanzania, if the parties are Tanzania and British, UK, either the UK law would be followed depending upon the nature of the case, or the Tanzania would be followed over there. And even they can decide in the contract also, if any case of the breach, Tanzania court is having the jurisdiction to entertain the case. Suppose if it is not such a condition is there. At that time, we apply the various lex loci contractors will not play an important role because it leads only the formalities of a contract. When the matter comes, execution of the contract is made in Tanzania, where the lex causa is in Tanzania, At that instance, plaintiff is having every right to file a case in Tanzania, and the applicable law is Tanzania. Is it clear? Yes. Is it clear? When there is no choice of option there in the contract, at the time, the local law, the municipal law, or the where the case is filed, lex forum, substantial law would be followed. That is to say, lex loci contracts govern only with respect to the forms and solemnities of the contract. There is extrinsic validity. For the intrinsic validity is generally governed by the national law of the parties, either the Tanzania or the UK. It depends upon the case of the breach. So now, choice of law by the parties and exceptions. The right of the choice of law is there for the parties. They can choose any country law, even though they are not hailing from that country, either one of the party. So general rule is there. The parties to a contract, cursor, the parties to a contract may select the law by which it is to be governed, and adopting a foreign law as a choice of law, the foreign law shall be deemed to be the incorporated in the contract as a set of terms. So parties is having every right to choose any country law, even though they are not belong to that country. Can you read the exception which I am highlighting here? Can you read the exception which I am highlighting here? Anyone? Unmute and read. Anyone can unmute and read, which I highlighted there.
Okay, Prof. Exceptions are: 1. Where the foreign law chosen is contrary to the peremptory provisions dealing with matters impressed with public interest. Number 2. Where the relationship of the contracting parties affects public interest in the country of one of the parties.
See,
Number 3.
okay, go ahead.
Where the substantial contacts arising therefrom point to the law of another country as the applicable law.
See, whenever you are making such a rule, please keep in the mind whether public policy is there or public, contrary to the public interest, contrary to the policy of the state, and at that time you are not supposed to choose the law of the other country. So where the foreign law chosen is contrary to the preemptory provisions dealing with the matters, means contravention with the provisions dealing with the matters impressed with the public interest of the nation. At that instance, we cannot choose such a law. Number 2, where the relationship of the contracting parties affect the public interest. Suppose you cannot have a contract with the country where the country is the enemy to the Tanzania, or they are making war against the Tanzania. You are not supposed to make a contract with that country because it is the enemy country, alien country. So where the relationship of the contracting parties affect the public interest in the country, one of the parties, where in that country you are the one of the parties. Number 3, where the substantial contracts arising therefrom point of the law of the another country as the applicable law. Suppose Tanzania doesn't have a admiralty law so advanced. Do you know what is admiralty law? Do you know what is admiralty law? If you know, you tell me. If you don't know, you say pass on.
Pass on,
Pass on.
Prof.
Admiralty law is nothing but marine law. Marine law, sea navigation. And marine law and sea navigation, admiralty law, Tanzania law is not that much advanced. Even the India law is not that much advanced. But whose country law is very much advanced? UK. Is very advanced. And for other disputes, Jamaica, Kingston, where the law of the sea institution there, they do the research. And they can develop the law. You can take the opinion of their experts and we can follow the law of England or the law of Jamaica, even though the party is not hailing from the Jamaica, any one of the parties, because one party from the India, say another party from Tanzania. When they made a contract in such a manner, if it is Admiralty contract, Marine Sea contract, or something coming export and import through the water, via water, and at that instance, they can choose the Admiralty law of the another country where the system is more advanced. So that is the thing. Where the substantial contracts arising thereof point of the law of the another country as the applicable law. So applicable law for the Tanzanian or the Indians when the dispute comes over there in the marine matters are concerned. At that instance, even though any one of the party is not from the UK, but they can choose the law of the UK as applicable law. I say as applicable law. I did not say file a case in England. I say applicable law is England law. Okay, you can, as per the agreed one, either you can file a case in the India or you can file a case in Tanzania. But the rule is plaintiff should not be put it in trouble. Means forum convenience. From where the plaintiff having the convenience to file a case, let the plaintiff will file a case in that country. Is it clear? Say yes.
Prof, I did
Yes,
not get
sir.
point number 3 at all.
You did not catch it.
Number 3, yes.
See, where the substantive contracts arising therefrom point of the law of another country as the applicable law. See, when the law is silent in the Tanzania and India, substantial law I am speaking about, where the substantive contracts arising therefrom point of view the law of another country as the applicable law. So there comes 2 points. Number 1, where the law is silent, at that instance, we can choose the law of the other country. Number 1. Number 2, suppose the contract execution is in Tanzania. Major execution is Tanzania. Substantial contracts arising therefrom point of view the law of another country, because contract made in India, but the substantial thing is going on the contract in Tanzania. At that instance, Tanzania law would be applicable. Contract made in India, lex lucidity contractors, only formalities and procedure law would be followed for the essential conditions of the contract in India. But the substantial law, because the contract will be executed in Tanzania, at that instance, the more contract of the transaction in the Tanzania, at that instance, if there is no specifically mentioned over there in the contract, then applicable law is the place where the breach has occurred. The breach has occurred in Tanzania, hence Tanzanian law could be applied. Number 1. Number 2, the contract execution is in Tanzania. At that instance, local law, Tanzania law would be applicable. Is it clear now? 2 probabilities I told you.
Yes, yes.
See, in contract, no, you have every right to choose. You have every right to choose any country. And you have every right to choose any country applicable law. Because it is you agreed. Then what is the problem to the court? If it is a contrary policy is there, or you are having contract with the enemy country, yes, there is the public interest. And hence, such contract cannot be challenged or cannot be entertained. So contract stipulations, of course, Philippines law or the law of the registry, whichever is higher, they made the one of the, a Philippine law is a little different would be there, the law of the registry. So now let us see what is the case. Norse Management Company versus NSB, GR number. Okay, now Norse Management Company, enough. NSB we could remember or not. The Norse Management Company case law, it says, the deceased husband of a complainant herein was employed as a second engineered by the respondent and served as such a in the vessel. You know what is vessel? Do you know what is vessel?
Ship.
Yes, sir.
What is that? Don't say
It's a
yes, sir.
ship.
Give the answer.
Ship.
It's a ship.
Yes, a big ship
Sir.
is called vessel. Okay, the deceased, he is no more. Okay, husband of a complainant. Who is complainant husband? The deceased. Husband of a complainant. Here it was employed as a second engineer. Means second engineer means, do you know what is second engineer? Original employer is different. But he will be deputed over there to work another company because of the mutual understanding is there. At the time, second engineer by respondents and served as such in the vessel. An empty cherry earl, that is the vessel name it seems. While at sea, he suffered the epileptic stroke. You cannot remember the epileptic stroke, you say the stroke, and died 4 days later. Complainant widow thus filed a claim for the death of benefit of the contended that in determining the amount of the claim, the law of the Singapore, where the vessel is registered. The vessel is registered where? Law of the, Singapore. When the vessel is carrying which bandera? Bandera, flag. Vessel is carrying which flag at the time? When it is registered in the vessel in Singapore, naturally Singapore flag would be there. Am I right? Am I right? Did you understand the question? Answer. Any country where the ship is registered, that country flag will be hoisting in the vessel pole. So now should be considered. For this part, the respondent argued that Philippine law should govern, considering that the law of Singapore was never presented and the NSB cannot take the judicial notice of the foreign laws. And the issue is whether not the law of Singapore ought to be applied in the case. Now you tell me, deceased where he died? Give me the answer. No, if you don't give the answer, I cannot go further.
Pass on.
Deceased died where? Deceased got the stroke while on the sea, vessel is going on, there's the empty cherry owl, and died 4 days later. Complainant widow, she filed a case. Then Singapore law would be applicable or not, or which law could be applied over there. When a person died in a ship having the flag of or registered in the Singapore, naturally the Singapore law would be followed, or the place where he died, even that country law should be followed. Because high sea is not anybody's country. Are you following me? High sea is not anybody's property.
Yes,
Yes,
Professor.
yes.
Only there is a nautical miles. 3 nautical miles would be the property of the country where the country is attached with the shore. There is public international rule. There is the law of the sea. So here, whether or not the law of the Singapore ought to be applied in the case, and SC held that affirmative. Yes. The reason is here, the fellow died in the ship, and the ship belonged to Singapore. And the Singapore law would be applicable for the damages. On the issue of that, Singapore law was not presented before the NSB, And the Supreme Court held that NSB, being an administrative and quasi-judicial body, is not bound strictly by the technical rules. It has always been the policy of the board that cases of the valid claims for benefits of the account of the injury or death while in the course of the employment, the law of the country in which the vessel registered shall be considered. Is it clear now? We don't
Yes,
see
sir.
whether the which country law would be applicable is there, not there, doesn't matter. A person, a deceased died in the ship which is registered in the Singapore, that is enough. Moreover, the employment agreement stipulated that compensation shall be paid under the Philippine law or the law of the registry of the vessel, whichever is higher. See, benefits will be given to whom? Plaintiff. Thus, the amount under Singapore law being the higher, the same should be applied in accordance with the stipulation. Whichever is higher, suppose the Philippine law will says only limited liability, means cap, CAP cap. But Singapore law say unlimited liability. Then the court will give unlimited liability to the plaintiff. Because that is the advantage. A person who comes to the court should not go with the empty hands, number one. Number two, justice to be done, and it seems to be done. Is it clear? You should say in the meantime,
Yes,
yes,
Professor.
sir, no, sir. Repeat, sir, you have to say, so that I could know that I am with you and you are with me. And both are traveling in the same boat, reaching to the destination. So now I read this one, contract law of the parties, which I am highlighting here. Contracting law of the parties. Harper. Anyone? Read.
Contract is law of the parties. Begong Philippines Overseas Corporation versus NLRC GR number L660006 February 28, 1985. Facts. Pancho was hired a Bangkok Philippines Overseas Corporation as an oiler on board the MV Olivine, a vessel registered in Hong Kong, while the vessel was docked at Gothenburg, Sweden. He suffered a cerebral stroke and he was rushed to the hospital. Later, he was repatriated to the Philippines where he died later on. His widow filed for compensation benefits with the NSB, which board awarded her the disability compensation benefit under the employment contract. NLRC, however, modified the decision and instead applied the law of Hong Kong, awarding a higher amount of benefit to the widow.
Yes. Now the question comes. Issue is that whether or not the Hong Kong law should be applied. Where is the ship is registered? Vessel is registered in Hong Kong. Is it clear? Say,
Yes, Pro.
and while vessel is docked at the Gothenburg, Sweden, the vessel at the time in the Sweden water, and there he suffered a cerebral stroke and he rushed to the hospital. Later he was repatriated to the Philippines. He sent back to the Philippines, and in the Philippines he died. Can you consider the Philippine law where he died? Can you consider where the mishap occurred, that is the Gothenburg in Sweden? Or can we consider the law of the ship where it is registered? Do you know what is meant by registered? Do you know what is meant by registered?
Yes, sir.
If you buy a vehicle, you registered with the Tanzania authority, means the Tanzania Transport Authority. If you are using in Tanzania, can you buy your vehicle Tanzania and register it in Kenya? Answer is yes, because you want to use it in Kenya. At the time, if any mishap occurred over there, then the law of tort, it varies where the cause of action occurred. Torts I am speaking. And here the contract. And in the contract it says whether the Hong Kong law would be followed or Sweden law would be followed or where he died Philippine law would be followed. That is the question, whether or not the Hong Kong law should be applied here or not. Let us see that what is held. Supreme Court held that employment contract should be applied, not Hong Kong law. The case of the Norso management cannot be precedent because it was expressly stipulated in the employment contract. In that case, that the workman compensation payable to the employee should be in accordance with the Philippine law or the workman insurance law of the country where the vessel is registered, whichever is higher. Such stipulation is not found in the employment contract between the Pancho and Bagong Philippines Overseas Corporation. At that instance, they say they cannot follow the law of the Hong Kong. Because in the earlier case, it is clearly mentioned in the contract. But here, there is no such a thing would be there, and hence, where the mishap occurred, the Sweden law would be followed, whether it is a more amount or less amount. But the point is no, in the contract terms, how it will be dealt. For the death, how much the compensation, or the negligence of his own party is there, how much the compensation. So depending upon that factor, they will make it out. But here, contract terms are very much important. And the terms, as per the terms, they will decide the case. Sir, in the above case, there is no such a term in the contract. It is clearly mentioned here. In the Narso case, they said, what happened in the Narso case? It will not be a precedent because it was expressly stipulated in the employment contract. In the case that the workman compensation payable to the employee should be in accordance with the Philippine law. So it is clearly mentioned in the employment contract that the Philippine law would be applied. At that instance, they follow the Philippine law only, even though the fellow got the stroke in Sweden. Is it clear? Is it clear?
Yes, Prof.
See, in the contract now, always what are the terms and conditions are there that will prevail. Of course, there is no, Dorcas, you are speaking with your family, I could hear your voice. Dorcas, you mute it, your face, speaking with your family members. Darsani, you are saying. Okay. Now let us see the exceptions. What are the exceptions? When the contrary to the public policy, you said no. The Pakistan International Airlines Corporation versus Opel. If you don't remember the Opel, forget about it. At least you remember the Pakistan International Airlines Corporation. What are the expressions when the contrary to the public law? And you say, Pakistan International, a foreign corporation licensed to do the business in the Philippines, executed 2 contracts of employment with the private respondent to their services as a flight stewardess. The contract had a term of 3 years, but also with the stipulation that notwithstanding any provisions to the contrary, the employer reserves the right to pre-terminate it any time. Pre-terminate means before the period is completes. Before the expiration of the 3 years term, Pakistan International sent a notice of dismissal to the private respondents, prompting them to file this case for illegal dismissal and recovery of the wages and other benefits. So the issue is whether or not there is stipulation in the contract as to the right of the employer to terminate the employee at any time should be respected. In the contract terms, they will say, at any time, the employee can be fired. without giving the notice and without showing the reason. It will be there in the contract. Do you think that it is the validity of that contract is valid in the court of law? Answer is no. Because you cannot take the advantage of hiring a person without reason. So, unless it is a retrenchment is concerned, you cannot hire a person without showing the reason. Even though the provision says in the contract, it is against the public interest, against the morality. Is it clear? Say, is it clear?
Sir.
See, a passerby is there. Without any cause, without any justification, can you beat him?
No, Prof.
You cannot beat him. Even though you are an enemy to you, doesn't matter. You are not supposed to beat him. If you want, you can give the complaint against him in the police station. Am I right? Say yes.
Yes, sir.
You cannot take the law into your hand. You cannot take the law in your hand. Is it clear? So,
Yes, Prof.
a contract freely entered should be respected, since a contract is the law between the parties. The principle of the party autonomy to the contract is not, however, an absolute principle. The rule in Article 1306 NCC clearly mentions contracting parties may establish such a stipulation as they may deem convenient, provided they are not contrary to the law or morals or good custom or public order or public policy. Suppose if you have gone to a movie and you park the car and they say, the owner says, which cinema owner says, proprietor, people are parking the car at their owner's risk. But when such a thing would be there, why the amount will be collected? Say 10 rupees, 5 rupees. It is the burden of the supermarket. It is the burden of the theater to see that the car should not be stolen from their premises. Even though you keep a policy, parking in the park area at the owner risk, then why did you keep the parking there? Tell me. You cannot scot-free by keeping one sentence. Owners are responsible for their own car, not the owners of the premises. Then why did you keep the parking there? So they say, contracting parties may establish such a stipulation. They are deemed convenient for the provided, but they are not contrary to the law, is not contrary to the morals, not contrary to the good customs, nor contrary to the public order, nor contrary to the public policy. Thus, counterbalancing the principle of the autonomy of the contracting parties in the equally general rule that the provision of the applicable law, especially the provision relating to the matters that affected the public policy, public interest, morality, and against the natural justice, contract heavy applicable provisions of the especially preemptory, and the law relating to the labor and employment is clearly such an area that the parties are not in a liberty to insulate themselves and their relationship from the impact of the labor laws and regulation by simply contracting with each other. I don't know, in the Gita means, is it a open cast mine, or is it an incline, or is it a shaft? In mines are three types. Open cast means you can see the sky. You can look at the bingu. It will not be underground, just excavating it. And incline means you go under below the earth in 45-degree angle. That is called incline. And shaft means you can go only with the lift. It will take you at least 1 kilometer, 2 kilometer down, and from there you can walk. You can go to the various directions. But it is below the underground. The mine people say, if anybody died underground, we are not responsible. The employer will say, you have given the free consent to work underground, hence we don't pay any amount? Answer is, you cannot say so. Because for the livelihood he is doing the work. He has not given the consent freely to you. He has given the consent because he wants to survive. It doesn't mean that he will take away his life. If the responsibility of the mine to see all the employees, those who are working underground, should be safety. Safely should have to work. The safety regulation should be followed. Okay, if employee himself is negligent, okay, at the time, okay, there is some justification is there. The full payment cannot be made. It is called proportionate amount will be there. If the negligence is 50%, 50% will be the awarded because he himself is negligent over there. In the mine, you are not supposed to smoke. Are you following me? I am speaking about the underground mine. In the mine, you are not
We are together.
Yes. Yes, tell me, Dorcas.
Yeah, we follow it. We follow it.
You are not supposed to smoke underground because in underground there may be gases are there, they will ignite. So if you smoke it, if the gas has emerged and where you engulfed in the fire, and if you died,